Hi, good morning. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I wanted to explain how we go about settling a case. So here's an example of a case that we're trying to settle, and it's a car crash. It's not our client's fault at all, and he has a serious injury, including the need for a total knee replacement surgery, where they go in and they replace the knee and you have an artificial knee. So it's a very serious injury. So anyway, a lot of lawyers, the way they would approach a case like this is they would call and they would make a demand, a demand for settlement, a settlement demand. And that's what a lot of the insurance companies want you to make. That's what the defense lawyers call you and say, hey, what's your demand? Even when you go to a settlement conference with a judge, the judge will say, what's your demand? I personally hate the word demand. My demand is a jury trial. What I do is I give them the opportunity or the chance to resolve the case, and I give them time, like 30 days. So in this case, we had a mediation, and another attorney from my firm went to the mediation, and there was some talk, and at the mediation they offered us a pretty nice number. They offered us $700,000. But I thought, after consulting with the client, the other attorney, everyone in my office, we thought that was too low, so we gave them the opportunity to resolve the case for $3.25 million. And we based that upon the fact that the defendant, who hit our client in the rear and was at fault, had a $250,000 insurance policy, but he also had $3 million excess. So we based it on that, and we thought, look, this is a tender type case. So we asked for $3.25 million. We told them that is civil justice in this case. That is our settlement value. We didn't really ask for it. We just said, that's your opportunity. You have the chance to settle. And we sent a letter on January 14th. So it was actually due Valentine's Day, February 14th, for their response. But instead of responding, they kind of said, look, we need more time. We're not sure. Please give us more time. I said, look, whatever time you need. I gave them 1 extension, 2 extensions, 3 extensions. What the guy ended up doing, the insurance company adjuster, he fired the law firm that was defending because he got scared, whatever. He fired the law firm, hired a new law firm. So he's like, no, I have this new law firm or whatever. Speak to them. I'm like, well, whatever, who cares? So then I gave him more extensions after he got the new law firm. I said, have the new lawyer has to review everything, get up to speed. I'm like, sure, whatever you need. But all I'm looking for is for you to accept my opportunity, or if you don't accept the opportunity, give me a good faith offer in response. So today, this morning, he sends me an email, and he basically says, look, at the mediation, we offered you $700,000. Then all of a sudden, your demand went up by a lot. And nothing's really changed with the case. It's still the same case. So I'm still at $700,000. And that was his response, right? So I sent him an email then again in today. And my email was basically telling him as follows. I said, it may be fun thinking I should have caught that train that left the station at 11 a.m., but it's 11:16 a.m. now. So that train is gone forever. We never, quote unquote, demanded $700,000, and I honestly hate the word demand. We provided a clear and unequivocal opportunity for your insurance company to resolve this matter for $3.25 million, or to provide a good faith offer in response. We then extended the deadline numerous times to do so based on your representation that a good faith offer would be forthcoming. Today, I receive a letter regurgitating the prior lowball $700,000 offer. So it is my understanding that your insurance company has now made the choice not to protect its policyholder, and I name the policyholder, from the substantial likelihood of a verdict in excess of his policy limits. Because remember, all he has is 3.25. So if we hit for like 4 or 5, who's going to pay the difference, right? So that's what we're setting it up for bad faith, where if I do get 4 or 5, they have to pay the difference because they had the chance to settle for 3.25, which they chose not to do. So then I said, we believe this may be bad faith conduct since your insurance company must place Mr. S, I'll call him Mr. S's interests or his financial interests on an equal footing with your own financial interests, and that's the case law in New York. The minimum amount we would now consider to settle is $4 million and will likely continue to increase as we spend time preparing for trial. Thank you and have a nice weekend. So that's how I do it, And we did it in another case, actually from a YouTube viewer, and she actually had a great question. She said, well, what happens if they don't accept the settlement opportunity? Does that mean that the case is now like stalled or something? And no, the answer is no, right? Because you have the litigation track, which is filing a lawsuit, having the preliminary conference, doing depositions. You know, that's the litigation track, discovery, then going to trial. And then you also have a settlement track, which is like, could be done at any time. It could be done before you file suit, during depositions, even during trial, right? So they're two separate things. Like one does not affect the other. It's just a chance to settle. If they say no, you still continue, you do depositions. Like in this case, we've already done depositions. We're on the calendar. We're gonna get a trial date probably in the next few months. So. Okay, everyone, I hope this was helpful. Have a great day. But you see, this is the way you have to deal with these insurance companies, because they just, very often they choose not to be fair, and you don't want that lawyer who's afraid and just gonna say, oh, you're not gonna give me more, I'm just gonna take it. Because a lot of lawyers would settle this case for $700. But you know, I think, look, if they have $700 on the table, I wanna try to push the button. I wanna push the envelope. I wanna try to get my client maximum justice. And look, worst case, push comes to shove, we could always settle it maybe for 1 point something, 2 point something later on. But I really think this is a case where it really is a clear tender, because we have the human story, we have economic damages, we have the injury being very serious, we have surgery. Actually, I didn't mention there was a discectomy to the neck, as well as the total knee replacement. There was also a lumbar surgery. So when you look at it all together, it's just way in excess of the policy. So I don't really understand what they're doing. And in my letter, you know, it's a 15-page letter that I write. In my letter, I actually even told them, here are all the elements of damages, like pain and suffering, loss of enjoyment of life, future medical costs. I actually put it in a nice table and I explained it. And I said how each element is actually really conservative and really low, but they didn't respond to that. They just give me a lowball 700, because in my tables, the amount actually comes out to 4,652,000, and that's low. So, and they just don't respond. So, you know, fine, we'll just go to court. Okay, everyone, have a great day. Bye-bye.